Welcome to another episode of 10 Minute Land Surveyor. I'm Dave Woolley. Today I'm going to be talking about legal descriptions. Not so much on how to write legal descriptions, but more how legal descriptions affect the land tenure system and the legal framework behind a description. In California, you will note that there's a uniformity in the legal descriptions. And the reason for that is we rely on one book. That book is Writing Legal Descriptions by Gurdon Wattles. Wattles is the preeminent resource for writing legal descriptions. Essentially, if you don't follow Wattles, you're probably doing it wrong. Also, February 9th, 1943, the state engineer for the California Department of Public Works issued a memo. If you look at the screen, it's shown here. This memo is titled Descriptions and Survey in Their Relation to the California Land Titles. And if you look at it closely, it says here that the William C. Wattles, chief engineer for the Title Insurance and Trust Company, wrote a syllabus. The syllabus is actually what became the book that we're all familiar with in California. It is requested that a copy of this syllabus be placed in the hands of each right-of-way agent and right-of-way engineer for their information and guidance. And I have the entire syllabus. If you're familiar with Wattles' book, you can see that book within the outline of this syllabus. Something else for the history buffs is you'll notice that there is a advertisement to buy victory bonds because in 1943, we're in the middle of World War II. If you want to research the laws that govern the legal descriptions in California, you're not going to find much by way of legal description. What you have to look under is California contract law, which is a derivative of the statute of frauds. Most land surveyors are familiar with terms and phrases like you cannot convey real property with an oral agreement, and that's something we all understand. But that's actually part of the California Civil Code, Civil Code 1624 and Civil Code 1091. And what that says is that contracts for real estate must be in writing. That's why the legal description has to be written very precisely and very accurately, because in the event of confusion in a contract, they will end up in a court. Now, even that is part of the Civil Code, Civil Code 1598, which talks about the clarity of terms of a contract. As to the intent of the parties, that's in Civil Code 1636. I'm not going to read these codes to you, but you should be familiar with the codes that govern legal descriptions, which are actually the codes that govern contract law. This list is not an all-inclusive list of the Civil Code with which the land surveyor should be familiar, but one last section is Civil Code 1577 and 1578. That relates to the location of legal descriptions on the ground and contract rescission. Now, the reason that you want to know these sections is in the event that there's litigation, in the event that there's liability, in the event that you are writing legal descriptions and you don't know what you're doing, this is the legal framework by which these deeds are going to be interpreted. Another principle is what they call the four corners. And you can look that up on Google. And what it says is that you're going to read the contract by what it says, by holding it in the four corners. You're not going to add to or take away from anything written between the four corners. The intent of the deed, and this is where a lot of surveyors screw it up, is they will insert the intent of the parties by way of their version of it. And that's incorrect. The intent of the parties is that which was written. So their intent is what is between the four corners of the document. And a surveyor should be loath to reach into that document and determine the intent of the parties if that intent is conveyed within that legal description. One of the classic examples of reading intent is closing gaps. You have a 100-foot parcel and you have the east 50 feet and you have the west 50 feet. And you go out and you measure 101 feet. So both of those parties are whole. They each own 50 feet. They bought 50 feet. Their contract says they have 50 feet, and the 50 feet can be laid on the ground. There is a 1-foot gap in between there. Now, what a fool will do is they'll say, well, the intent of the parties was to divest themselves entirely of the 100-foot lot. And that may be true, but that's not what they did. The intent is what was written and what was conveyed, and all the parties are whole, and there is a 1-foot gap. And it is incorrect for a surveyor or anybody else to read into the intent when the intent can be determined from the four corners. And this example is backed up by the evidence code. Again, that's for another video. Now, this is just a brief glimpse into the history of legal descriptions. Over my shoulder, you'll notice there's a book, and this book's by Hernando de Soto, and it's called The Mystery of Capitalism. And in that book, de Soto says that the reason that the West, particularly the United States, is so wealthy is because of the stability of our land tenure system. The fact that you can buy land, you have a unique description, and that land is protected by our Constitution, allows lenders to loan money on the land and to develop the land because there's security in the land. And that security comes from a rigorous legal structure that is anchored in these legal descriptions. Now, that duty is very specifically assigned to the California Land Surveyor under Section 8726 of the Business and Professions Code. In that section, it says that only land surveyors are legally authorized to write legal descriptions for real property. I'll talk about exemptions in a moment. So, being that this is your duty exclusively, and being that our entire land tenure system anchors on it, this is not something that any surveyor should take lightly. Now understand that we have licensed land surveyors that have went completely rogue and they're writing legal descriptions without having even opened up Wattles. And it becomes quite obvious when you look at these descriptions that they have no background. Now, one of the interesting things about these folks is oftentimes they think they're awesome at writing legal descriptions. How do I know? I check hundreds of legal descriptions a year, and I talk to these folks, and they decided that they know better and that they're actually going to rewrite the rules of conveyances. For example, they'll come up with a rule within their jurisdiction that all legal descriptions must be a metes and bounds description. Well, that's not in Wattles. That's not true. In fact, metes and bounds descriptions, when there's an alternative, are one of the poorest legal descriptions that you can write. They're subject to errors because they're longer than necessary, and as Wattles used to say, clear, concise, without ambiguity. Well, a metes and bounds description is not always clear, not always precise, and oftentimes will have ambiguity. For example, if I have lot 1 and I'm going to convey the east 5 feet for right-of-way purposes, it's much better to say the east 5 feet of lot 1 than it is to say beginning at the northeast corner and run the chance of adding an ambiguity into that legal description. Okay, I said I was going to talk about the exemptions to being licensed and writing legal descriptions. Section 8730 of the Professional Land Surveyors Act, or Business and Professions Code, says that if you have revenues that exceed $25 million annually, and you're basically a public utility, gas, electric, so on and so forth, that there's an exemption to the licensure. But it's not a blanket exemption. The exemption is very well outlined in that you have to be an officer or an employee of that company. Now, what I'm seeing here in Southern California is we have chop shops, and there's no licensees involved, and these chop shops are saying that they're exempt because they work exclusively for Southern California Edison. Well, it very clearly says an officer and an employee. It doesn't say contractor or subcontractor. So when you look at a public utility description and you see that it's not awesome, it's because they're subcontracting to unlicensed people. Now, it's not that licensed people always do these great descriptions, but there's a better opportunity if you have a licensed person involved that the description will follow the norms. And it gives the licensing board and the courts recourse in the event that a licensee messes something up because there's a negligence that can hang on their license, or there's negligence in a standard of care as opposed to unlicensed practice that can cause liability and can trip an errors and omissions insurance. But what these utility companies do is they hire these unlicensed companies who work for dirt cheap dollars, and they backdoor these descriptions in thinking they're saving the corporation money. And these folks are not officers or employees of it, and therefore it's an illegal practice. And I've spent some time trying to get my arms around this and to bring these into conformance, but it hasn't really been that successful. I actually went and interviewed at one of these firms just to get inside and actually what's going on inside one of these chop shops is they have college kids writing legal descriptions off of AutoCAD plans of construction plans. But that's going to be a story for another video. Now, something else I've run into recently is I have surveyors trying to convey interest with just a plat. There is no written legal description. And interestingly, the law doesn't specifically prohibit this, but it creates land title problems. Therefore, it creates negligence. Let's talk about it. On the screen, you'll see a parcel, and this parcel is clearly delineated. It's locatable on the ground as a boundary. So the deed jacket says that portion shown on Exhibit B attached here to and therefore made a part of. So let's talk about that. What is the actual legal description of this property? How am I going to ensure this? How am I going to convey this? The legal description is actually Exhibit B. Now, how many Exhibit Bs are there out there? There's a reason we don't do this. Now think about this. We didn't use plats for the better part of 100 years. Occasionally you'll find a plat associated with a deed, but for the most part, all these deeds and all the real property conveyances were done with a written legal description. In California, up until 1972, you could subdivide property with a legal description. So ask yourself, why didn't they just convey the property with plats? Well, because the plats are not stable, they're not locatable, they're not insurable. We went 100 years without ever having plats, and now we have legal descriptions and plats, but we cannot make a transition to conveying property with plats because it has no legal description. It has no contract value. And so I see agencies starting to accept plat onlys. That property shown on Exhibit B. If given a choice, they could have done plats in 1900, 1930, 1950. They've always had the ability to draw plats. They knew they couldn't convey property with a plat alone. And you look at the adjoiners, what would that be? Lot 1, except that portion shown on Exhibit B per another document, doesn't follow the tradition of what we do. And legal descriptions and land tenure is about cohesiveness. And so you should not be writing conveyances that refer solely to a plat, because the plat is not a legal subdivision in the same way that a parcel map or a tract map or the way that legal descriptions were written prior to 1972. Imagine this, if you're going to sell this parcel or you're going to incorporate this parcel into something, how's it going to get an APN? It doesn't have a legal description. The legal description is Exhibit B. Again, the courts in California don't specifically say you cannot do this, but don't do it. I'm going to run through a quick list of things that you don't do when it comes to legal descriptions. I've already covered that you do not convey property with a plat only. You don't use references to documents that are not retrievable in a public access system. I'm familiar with some litigation in which they wrote legal descriptions and they said, as shown on an ALTA by XYZ surveyor this date and time. And that ALTA is not retrievable. It's not a legal document. Don't do that. Don't say more or less after every distance. That's donk. What you want to say is the word to. So when you say a bearing and distance to the north line of Lot 1, that means more or less. So you don't need to write more or less after your distances. Don't create conflicting conditions. Always recognize the adjoiners. And so you will say to, parallel with, along. These recognize senior grants or the rights of others. You never write strictly a bearing and distance when you're fitting within adjoiners. And because all the land in California has been surveyed for the most part, every meets and bounds description will have a to, along, parallel with, or something similar because you're not doing first divisions of land. Another big no-no, don't do double calls. For example, thence north 00 east 100 feet to the north line of Lot 1 being 100 feet east of the northwest corner, also being 100 feet west of the northeast corner. That creates two locations. That's donk. Don't change legal descriptions that are already in the record. You may have a legal description. It may be less than ideal, but do not change that legal description away from the original and change the title, because that title has been conveyed and held in a certain manner, and you may be able to write that description better, but you do not deviate from the original description. One of the things you always want to do is establish a basis of bearings for your legal description. So you're always going to start at a known point, you're going to continue to a known point, and then you're going to begin your description. That way it establishes a basis of bearings based on a known record. Although it's not always required, it's not incorrect to add a basis of bearings statement to your legal description. It is required in the event that you're using state plane coordinates because you have to follow the California Public Resource Code. Do not describe property with coordinates. It's actually prohibited in the Public Resource Code. You must have bearings and distances, and you must cite underlying records. I guess you could say, don't do anything illegal. When you're writing a legal description for an easement, state the purpose of the easement. Easements are the rights of another person to use the land of someone, and they're subject to litigation. And they need additional language beyond the legal description. You should work closely with an attorney on the deed jacket because there's issues like maintenance and access and hours of access that need to be addressed. And just because you're licensed and you're authorized by law to write legal descriptions, it doesn't mean you should. There's also in the law something that you have to practice within your area of competence, and everybody has to write their first legal description, but you should always have these legal descriptions reviewed by somebody that has experience with the legal descriptions. And frankly, I don't think there's any room for somebody to come in and start writing legal descriptions and reinventing the rules that aren't inside of Wattles. If you're doing that, stop it. Something we do at our company is all new hires get a copy of Wattles. They sign their contract for employment and we hand them a book of Wattles. That's how important it is to what we do. If you're going to write legal descriptions, you should have a copy of this on your desk, and you should not deviate from this book. You are not in a position to rewrite rules that have been in place in this state for well over 100 years. Oh, I just remembered another thing. If you're a surveyor or you know a surveyor that writes to a point at the end of the distances, tell them to knock it off. Wattles very specifically says, do not say to a point. And you know what? Keep an eye on them for other reasons too. That's very suspect. Thank you and have a nice day.